Hello, and welcome back to the Inquisitive Prosecutor's Guide podcast. I'm Jeff Rubin, and on this podcast, I'm going to be discussing a couple of cases involving the possession of weapons from the California Supreme Court, as well as a new search and seizure case from the United States Supreme Court. As our faithful listeners are well aware, although I generally prefer to be asking the questions of our guests, sometimes I ask fellow prosecutors to play host and answer the questions myself. That's what's going to happen today as Santa Clara County Deputy District Attorney Jeremy Avila joins me to discuss the cases of People v. Wade, People v. Castillo-Lopez, and Utah v. Strieff. This podcast is approved for 30 minutes of general MCLE credit. Jeremy, what case should we cover first?
How about People v. Wade, a recent California Supreme Court case dealing with whether a defendant who wears a backpack with a loaded firearm violates the statute prohibiting the carrying of a loaded firearm on the person.
Okay, so what would you like to know about the Wade case?
Well, for starters, how about telling me the facts that set up the issue for review?
Sure. At the defendant's preliminary examination, the people established that the defendant wore a backpack containing a loaded revolver while being pursued by a police officer. The defendant gets held to answer for violating Penal Code Section 28580, which prohibits the carrying of concealed loaded firearms. However, a judge later granted defendant's motion to dismiss under Penal Code Section 995, reasoning that a weapon carried in a backpack is not carried on the person as required, according to this trial court, by Section 28580.
Okay, before I ask whether the Supreme Court agreed with the judge who granted the motion to dismiss, let me ask you this. What exactly does Section 28580 say?
Okay, well, that section, which used to be 12031 up until a few years ago when the legislature inanely renumbered all the long-standing sections applying to weapons, that section states, a person is guilty of carrying a loaded firearm when the person carries a loaded firearm on the person or in a vehicle while in any public place or in any public street, in an incorporated city or in any public place or in any public street, in a prohibited area of unincorporated territory.
All right. Now let me ask you this. Did the California Supreme Court find a firearm inside a backpack being carried by a person is on the person for purposes of Section 25850?
Yes. They held a defendant who has a backpack on his person is, for purposes of Section 25850, carrying anything inside that backpack, including any kind of weapon in the backpack.
So do you think this ruling will govern whether a defendant who's carrying a backpack with a concealed firearm in public can be prosecuted for violation of Penal Code Section 25400, formerly 12025B, which prohibits the carrying of any firearm capable of being concealed upon the person?
Absolutely. The California Supreme Court specifically approved of an appellate court decision from 1976 called People v. Dunn. And in that case, the court had held that a defendant who carried a concealed firearm in his suitcase at an airport violated former Penal Code Section 12025B.
What about whether carrying a knife in a backpack in violation of Penal Code Section 21310, former 12020A4, which prohibits someone from carrying concealed upon his or her person any dirk or dagger?
It's going to, in all likelihood, apply, the reasoning of Wade is going to apply to that statute as well. In fact, they discussed an appellate court case called People v. Pellicer from 2013, which had held that the term upon the person didn't include a carried or adjacent container, such as the backpack, which in that case the defendant had been found leaning on. Now, they disapproved of the rationale in the Pellicer case, although they didn't necessarily disagree with the conclusion that Pellicer had reached, because in Pellicer, the defendant was seen leaning on a closed backpack. The backpack contained several knives, which were concealed dirks or daggers. But even though the Pellicer court had said that, or had indicated that you're not carrying a concealed dirk or dagger if you're carrying a backpack that contains a dirk or dagger, their actual conclusion was that in that case, the defendant couldn't be convicted of that statute, not based solely on that rationale alone. They also came to that conclusion because the police had never actually seen the defendant carrying the backpack. So that's why the court in Wade didn't disapprove of the conclusion, but they did disapprove of the idea that you needed to, you couldn't be convicted of violating a statute prohibiting the carrying of a weapon if the weapon was in the backpack. And I say that it's going to apply to that statute not just because of that disapproval of that type of rationale, but also because the Wade court favorably cited to the holding in an out-of-state case from Alaska that had affirmed a defendant's conviction of possessing a knife that was concealed on the person, where they said that a person who carries a deadly weapon in a purse, a briefcase, or even a paper bag commits the offense of carrying a concealed weapon.
So, in light of the holding in Wade and its approval of the Alaska case, is it safe to say that the default position in interpreting any statute that makes it unlawful to carry some item, quote, on the person, including Penal Code Section 21310, is to assume the statute will apply to items contained in backpacks or other containers carried by the person? Yes.
There are not a lot of statutes out there which deal specifically with prohibiting the carrying of firearms or other weapons that we have not yet discussed. But, for example, there's another Penal Code section out there, 4502, which prohibits persons who are confined in penal institutions from carrying upon their person certain weapons. The reasoning of the Wade court, in all likelihood, would apply to that statute as well.
Okay. So let's move on to the second case from the California Supreme Court involving unlawful weapon possession. It's People versus Castillo-Lopez. What was that case all about, Jeff?
Well, in Castillo-Lopez, an officer located a knife in the front pocket of defendant's jacket during a pat-down search. And the knife was a Swiss Army pocket knife, the kind you see in the stores all the time, with multiple blades. The largest blade, which was about 2 to 3 inches long, was in the pocket, but it was exposed in a, quote, locked position. And the way that the blades are sort of locked when it comes to these kinds of Swiss Army knives is it's held closed by spring tension, but can be opened by pulling on the blade. And then the blade can be returned to its closed position by just, pushing down or putting a little pressure on the back of the blade.
So there's no mechanism or button that must be pushed to collapse the blade?
No.
So was the defendant convicted of any offense based on his possession of the open-bladed knife?
Yes. In the trial court, he was convicted of violating Penal Code Section 21310, which makes it a criminal offense to carry concealed upon the person any dirk or dagger.
Why did the California Supreme Court even take this case up, Jeff?
Well, to determine whether possession of a concealed and opened pocket knife with a blade in its fully extended position fits the definition of a dirk or dagger.
And what is the general definition of a dirk or a dagger?
Well, it's given in Penal Code Section 16470, and it says a dirk or dagger means a knife or other instrument with or without a handguard that's capable of ready use as a stabbing weapon that may inflict great bodily injury or death. And then they describe some of the items that would qualify: a non-locking folding knife, a folding knife that is not prohibited by Section 21510, or a pocket knife that's capable of ready use as a stabbing weapon that can inflict great bodily injury or death, but only if the blade of that pocket knife is exposed and locked into position.
Was there any question that the blade of the knife was exposed in this case?
No. And that's why the California Supreme Court focused on the question of whether that blade was locked into position within the meaning of Section 16470.
So how did the California Supreme Court rule on the question?
Well, they looked at the ordinary meaning of the word lock as that meaning is applied to mechanical devices. And using that meaning, they determined that a pocket knife blade is locked into position if it's firmly fixed in position, and this is the language that they're using, by means of or as if by the interlacing or interlocking of parts. They said that a blade is not locked unless it is made fast. And when I say fast, or at least when they say fast, they use that term to mean that the blade is immovable or moved only with the greatest difficulty. They held that while a blade might be held open in a particular position by means of friction, like these Swiss Army knives, a blade that can be closed simply by applying pressure to the back of the blade has not been made fast, and therefore isn't locked into position as that term is ordinarily understood. They pointed out that the essential difference between a non-locking folding knife and a locking folding knife is whether the exposed knife blade is immobile, which would, if it is immobile, would prevent accidental collapse while the knife is in use. I don't think they wanted to look at a dirk or dagger as a kind of knife where if you're using it to poke someone and you hit bone or you hit something hard, it's going to collapse and cut your fingers. Those are not the kind of knives that are normally considered dirks or daggers.
So, if the blade cannot collapse unless a button is pressed, then it might qualify. But if all that is needed is simple pressure on the blade, like your typical Swiss Army knife, the blade is not locked?
Exactly. And since they found the blade of the Swiss Army knife in Castillo-Lopez was not locked into position within the meaning of Section 16470, it wasn't considered a prohibited dirk or dagger, and therefore the defendant's conviction had to be reversed.
Okay. Let's get to at least one of the two search and seizure cases issued this past week by the United States Supreme Court. Utah v. Strieff, a case involving the question of whether the existence of an outstanding arrest warrant that comes to the attention of an officer after the officer unlawfully detains a suspect but before the suspect is searched can preclude suppression of evidence obtained pursuant to the search. What were the relevant facts here, Jeff?
Jeremy, in that case, a police officer got an anonymous tip of narcotics activity at a particular residence. And over the course of about a week, a narcotics detective started conducting intermittent surveillance of the home, and he saw people visiting the home for just a few minutes at a time, suggesting that these folks were just coming into the house to buy drugs. Strieff, the defendant, was seen one day by the detective leaving the house and walking towards a nearby convenience store, and when the defendant got to the store's parking lot, the detective detained him and asked him what he was doing at the residence. As part of the stop, the detective asked for and received defendant's identification.
So what happened then?
Well, the detective then ran the defendant through dispatch and learned he had an outstanding arrest warrant for a traffic violation. The detective arrested the defendant pursuant to that warrant and conducted a search of the defendant incident to the arrest for the warrant. During that search, he discovered a baggie of methamphetamine and some drug paraphernalia on the defendant.
Now, did the defendant seek to suppress that evidence?
Yes. In the trial court, he argued that the evidence was inadmissible because it was derived from an unlawful investigatory stop.
Did the trial court find the stop was unlawful?
Yes, they did at the suppression hearing, but in part because the prosecutor conceded the detective lacked reasonable suspicion for the stop. The prosecution argued that even though they lacked reasonable suspicion for the stop, the evidence should not be suppressed because the existence of a valid arrest warrant attenuated the connection between the unlawful stop and the later discovery of the contraband.
So did the trial court deny the motion?
Yes, but the Utah Supreme Court reversed the trial court's ruling.
Why was that?
Well, the Utah Supreme Court believed that the evidence was inadmissible because they said only a voluntary act of a defendant's free will, like a confession or a consent to search, could break the connection between an illegal detention or arrest and the discovery of evidence.
Okay, so then what happened?
Well, the United States Supreme Court took up the case to resolve a disagreement among the courts about how to apply the Attenuation Doctrine when there's an unconstitutional detention and it leads to the discovery of a valid arrest warrant.
Now, how did they analyze this issue?
Well, they began by recognizing that to enforce the Fourth Amendment's prohibition against unreasonable searches and seizures, it's sometimes necessary to exclude evidence obtained by unconstitutional police conduct. And they also recognize that this exclusionary rule can be applied not only to the primary evidence obtained as a direct result of an illegal search or seizure, but to evidence later discovered and found to be derivative of that illegality. This is, the fruit of the poisonous tree doctrine. However, they also stated that because of the significant costs of the exclusionary rule, it is applicable only where its deterrence benefits outweigh its substantial social costs. The court then pointed out that this principle was the basis for several different kinds of exceptions to application of the exclusionary rule, three of which, they said, involved the causal relationship between the unconstitutional act and the discovery of evidence.
Now, what did the High Court identify as these three exceptions?
The first of the three exceptions they named was the independent source doctrine. And that doctrine allows trial courts to admit evidence obtained in an unlawful search if officers independently acquired the evidence from a separate independent source. So, for example, let's say the officers have probable cause to enter a home. They seek a warrant, but while they're waiting on the warrant, they enter the home unlawfully. The doctrine would allow evidence seized pursuant to the warrant not to be suppressed so long as the warrant was not based on information obtained by the officer or officers who made the unlawful entry. In other words, if they were going to get it anyway, there was an independent source for discovery of the evidence. And that was the first exception that they discussed.
What about the second exception?
The second one they discussed was the inevitable discovery doctrine, which allows for the admission of evidence seized pursuant to an unlawful search if it would have been discovered even without the unlawful search having been made. This inevitable discovery doctrine, it's closely related to the independent source doctrine. But when it comes to the inevitable discovery doctrine, for example, let's say they're searching for a missing body of a victim. The police interview the defendant, they obtain a confession, but they obtain a confession in an unlawful manner. But as it turns out, there's a search party for the body, and they would have inevitably discovered the body, regardless of whether or not the defendant had confessed and led the police to the body of the victim. So in that situation, they said, if the evidence would have inevitably been discovered anyway, they're not going to suppress the evidence.
Okay. Now, what about this third exception?
Okay, the third exception that falls in this kind of general category of exceptions the Supreme Court was discussing, they called the Attenuation Doctrine, or the Attenuation Exception. And it was this doctrine the court considered in deciding the Strieff case.
So can you explain for us, Jeff, how does the Attenuation Doctrine or the Attenuation Exception work?
Well, it allows evidence to be admitted when the connection between the unconstitutional police conduct and the evidence is remote or has been interrupted by some intervening circumstance, so that the interest protected by the constitutional guarantee that has been violated would not be served by suppression of the evidence obtained.
Is the Attenuation Doctrine limited in application to circumstances involving an independent act by the defendant? Say, if the defendant freely confesses to a crime, or if the defendant consents to a search after the initial illegality?
Well, the Attenuation Doctrine can apply in that circumstance, but it can apply in other circumstances as well. The Utah Supreme Court believed it could only apply in those circumstances, but the High Court disagreed. They said the Attenuation Doctrine evaluates the causal link between the government's unlawful act and the discovery of the evidence. And they said that sometimes that has nothing to do with the defendant's actions.
Did the Supreme Court of the United States discuss what factors go into determining whether the attenuation exception should prevent application of the exclusionary rule?
Yes. The majority opinion, written by Justice Thomas, it's a very clear opinion, stated that there are three factors to consider in deciding whether to apply the attenuation exception to prevent the suppression of evidence seized after conceitedly unlawful police conduct.
What was the first factor?
Well, first, they said a court has to consider the temporal proximity between the unconstitutional conduct and the discovery of evidence to determine how closely the discovery of evidence followed the unconstitutional search. This factor, they said, will generally weigh in favor of the defendant. And what I mean by that is it weighs in favor of not applying the attenuation doctrine unless substantial time elapses between the unlawful act and when the evidence is obtained.
Did the court identify or give an idea of how much time has to pass in between the initial illegality and the later search before the time period would weigh in favor of the state? That's to say, it would favor applying the attenuation doctrine?
Well, the Strieff majority did not set a specific length of time. However, the Strieff majority did note that in Brown versus Illinois, an earlier case from 1975, which the majority heavily relied upon throughout their opinion in Strieff, they said in that case, the High Court had found a confession following an unconstitutional arrest should be suppressed, in part because less than 2 hours separated the unconstitutional arrest and the confession. The Strieff majority described this time period as a short time interval that counseled in favor of suppression. So if the time is less than 2 hours, we can be pretty sure that they're going to weigh this factor in favor of not applying the attenuation doctrine.
All right. What about the second factor that was considered?
That's the presence of intervening circumstances between the initial illegality and the later search. And they said that an intervening circumstance can include the discovery of a valid, pre-existing, and untainted arrest warrant.
I see. And how about the third factor? What was that?
The third factor the High Court said has to be considered is the purpose and flagrancy of the police alleged misconduct. The court said this factor is particularly significant, and this factor reflects the fact that the exclusionary rule exists to deter police misconduct by favoring exclusion only when the police misconduct is most in need of deterrence. That is, when it's purposeful or flagrant.
So, is police misconduct considered flagrant if the police conduct a seizure without reasonable suspicion or probable cause?
The court said no. They said for the violation to be flagrant, more severe police misconduct is required than the mere absence of proper cause for the seizure. They also said that mere negligence on the part of a police officer, as opposed to systemic or recurrent police misconduct, is not considered purposeful or flagrant misconduct.
Okay. So, Jeff, did the High Court then apply those factors to the facts in the case they had before them?
Yes. They first looked at the temporal proximity factor, the time between the initial unlawful stop and the search, and they said that favored suppressing the evidence because the amount of time between the stop and the search was only minutes. But they found that factor was ultimately outweighed by two other factors that favored the prosecution use of the evidence under the attenuation doctrine.
Why did the second factor, that is, the existence of any intervening circumstance, why did that favor use of the doctrine?
The court found the existence and discovery of an outstanding arrest warrant was an intervening circumstance that strongly favored application of the attenuation doctrine because the warrant was valid, it predated the detective's investigation, and it was entirely unconnected with the stop. The court said that once the detective discovered the warrant, he had an obligation to arrest the defendant, and that this authorization to arrest the defendant made it undisputedly lawful to search the defendant as an incident of his arrest on the warrant and to protect the detective's safety.
Why did the third factor, the purpose and flagrancy of the official misconduct, why did that weigh in favor of the attenuation doctrine here?
Because the stop was just an isolated instance of negligence, at most, that occurred in connection with a bona fide investigation of a suspected drug house. The court said the detective had simply made two good faith mistakes, and they said that hardly rose to a purposeful or flagrant violation of the defendant's Fourth Amendment rights.
What were these two mistakes?
Well, the court said these two mistakes were stopping the defendant without knowing whether he was a short-term visitor. In other words, the detective hadn't seen what time the defendant had entered the suspected drug house. So he didn't know how long the defendant had been there, and therefore he couldn't say for sure whether or not he was a short-term visitor or someone who was there for a long time, which would be inconsistent with just going there to buy drugs. And then the second good faith mistake, according to the court, was demanding the defendant speak with him instead of asking the defendant to speak with them. In other words, the difference between turning it into a detention versus a consensual encounter.
All right. Did the court, though, did they give any reasons why the conduct was not considered a flagrant violation of the Fourth Amendment?
Yes. They pointed out that the defendant's conduct after the initial stop was lawful. He said you can do a warrant check. That's a negligibly burdensome precaution for officer safety. And they said the actual search of the defendant was a lawful search incident to arrest because at the time of the search, by that time the officer was aware of the warrant. And the court also pointed out that there was no indication that this unlawful stop was part of a systemic or recurrent police misconduct.
All right, Jeff, so give me the bottom line here.
Well, the court said the evidence the detective seized as part of his search incident to arrest was admissible because, primarily, his discovery of the arrest warrant attenuated the connection between the unlawful stop and the evidence seized from the defendant incident to arrest.
Okay, all well and good. Is this holding going to change how we analyze the issue of when an outstanding warrant will constitute an intervening circumstance?
Not really. In 2008, the California Supreme Court, in a case called People v. Brenlin, was faced with an almost identical issue to that in the Strieff case. In Brenlin, officers had made an unlawful traffic stop of a car without reasonable suspicion, and they discovered that a passenger had an outstanding arrest warrant, and they conducted a search incident to arrest and found controlled substances. The Brenlin court applied the very same factors relied upon by the Strieff court, and they applied a very similar analysis to the Strieff majority. California Supreme Court held that the discovery of an arrest warrant constituted an intervening circumstance that attenuated the taint of the unlawful traffic stop. So the holding in the Strieff case is not significantly different than the holding in Brenlin.
If there's an outstanding warrant that comes to light after an unlawful detention, will that always be enough to apply the attenuation doctrine?
Under Strieff, the existence of an outstanding arrest warrant that comes to life after an unlawful detention and before a search should, under most circumstances, prevent the suppression of evidence seized during the search. However, the Strieff majority indicated that there are some circumstances in which the police conduct could be so egregious that the existence of an outstanding arrest warrant would be insufficient to preclude application of the attenuation doctrine.
Did the court give any indication of when that could occur?
Yes. They hinted that if the detective had stopped the defendant solely to fish for evidence of suspected wrongdoing in the hope that something would turn up, this could potentially turn the third factor into a factor weighing against the application of the attenuation doctrine. Also, in response to the defense argument, the defense had made an argument that because these outstanding arrest warrants are so prevalent in many jurisdictions, that police would engage in dragnet searches, just go out there and start stopping people in the hopes that an outstanding arrest warrant would turn up. The Strieff majority responded to that argument by saying, look, if the police are engaging in these kinds of dragnet searches, evidence from such a search might be suppressed and they might not apply the attenuation doctrine.
Did the court identify any other types of situations in the Strieff case?
No, but in the case that I was talking about earlier, People v. Brenlin from the California Supreme Court, the California Supreme Court appeared to approve of a holding in People v. Rodriguez. Now, Rodriguez was an appellate case from 2006, which had held that if officers invented a justification for stopping a defendant's car, then any evidence seized after the detention would likely be suppressed, even though officers learned there was an outstanding arrest warrant for the defendant before searching the defendant's car. In other words, if they're just going out there and they're just making up wholesale reasons for stopping someone, that's going to be potentially sufficiently egregious to prevent application of the attenuation doctrine.
I see. So, Jeff, did the court give any idea on whether the existence of the warrant alone, just by itself, Did they give any idea if that could render an initial stop constitutional, even if the officer stopping the defendant remained totally unaware of its existence before searching the defendant?
No, they didn't decide that issue. They didn't weigh in on whether or not, for example, someone who has an outstanding arrest warrant could ever seek to suppress evidence seized when that defendant's arrested. They declined to decide that issue. They didn't need to decide it.
One final question before we finish. Earlier, you mentioned that the court said once the detective discovered the warrant, he had an obligation to arrest the defendant. In light of this language in Strieff, should it now be assumed that an officer must always arrest someone once the officer has been made aware of an outstanding arrest warrant?
Jeremy, one of the long-standing unresolved questions in California is whether an officer must, upon learning of an outstanding arrest warrant, even an outstanding arrest warrant for a traffic violation, whether they must arrest the person if they come into contact with the person and they're aware of the warrant. Now, I don't know if Strieff had this issue in mind when they made their statement, but certainly the U.S. Supreme Court appears to believe that such a duty does exist. I mean, aside from stating that once the detective discovered the warrant, he had an obligation to arrest the defendant, they described the warrant as a judicial mandate to an officer to conduct a search or make an arrest, and stated the officer has a sworn duty to carry out its provisions.
All right. Well, Jeff, I think that's all the questions I have in light of Strieff. And since you promised me I wouldn't have to miss my court appearance, I'm due there right now. So maybe we should just end it here.
All right, Jeremy, I realize your court appearance is an intervening circumstance, although it's an intervening circumstance that requires suppression of any further discussion. Thanks for joining me, though, and hopefully we can make this a more regular occurrence.